My name is Douglas Lodmell, Managing Partner of Lodmell & Lodmell. Welcome to our 2016 Client Update webinar presented by the Asset Protection Council. I am very pleased to be presenting to you today. If you're on this webinar, it means you're a client of Lodmell & Lodmell, and you've already taken the critical steps of protecting your assets. I love speaking with my clients. This is pretty much what I spend most of my days doing. And I want to begin today with a story. Last week, I was speaking with a longtime client named David. He had an issue regarding a subpoena he'd received and about what to do next. As we were wrapping up, he said, "Doug, I really want to thank you for being there to answer these questions even when they're not asset protection related. And I want you to know that having you there and having my asset protection plan in place gives me a sense of security and freedom that I can't imagine doing business or even living without." And then he went on to say, "I'm also really excited and looking forward to next week's Client Update webinar. And Doug, please do not be afraid to start at the very beginning and act as if I don't know anything about how my plan works." And his request really resonated with me because I know that most of my clients don't spend a lot of time thinking about their asset protection plans. In fact, this is one of the benefits of the way in which we draft our plans. They don't require a lot of separate attention. And I also know that you appreciate being reminded of how it all works. So today, I want to honor David's request, and we're going to start with a very comprehensive overview of the planning right from the beginning. We'll begin with the asset protection tools themselves. We'll talk about each tool, and we'll revisit how they work to actually protect your assets. As we look at each tool, we'll also discuss how they are funded, which is looking at each asset and talking about where in your planning it goes. We'll then put it all together and connect the tools and the assets into one comprehensive slide. And then I will take a few minutes to talk about what's happened in the world of asset protection in the past few years and how it impacts your planning, if at all. And we'll wrap it up with questions. And I know that there will be a lot of questions. There are several hundred people on today's webinar, and I will try to get to as many questions as possible. Please don't wait to type your questions into the chat box. My whole team is on this webinar today, and we will all be answering questions throughout the webinar. And if we don't get to your question today during the webinar, then I promise we will get to it by email, or if we need, we will call your office. And finally, some of you may have noticed that today's webinar is presented by the Asset Protection Council. I am very excited and proud to introduce the Asset Protection Council to you, my clients. Over the years, Lodmell & Lodmell has become known as a leader in the asset protection industry. And over the past few years, we've been getting more and more unsolicited calls and requests from other attorneys, financial advisors, and even CPAs to help their clients with planning. The APC is our official affiliate program and is designed to support those advisors and their clients with their asset protection needs. I welcome you to visit the APC website and encourage you to invite your own team to go there. You'll be seeing and hearing more about the APC over the next year, and you can be proud that you are a part of what we believe will be the world's leading asset protection resource. Thank you again for joining me today, and let's get started. Let's start with the goal of asset protection. The goal of asset protection is to create a legal barrier around your assets, which allows you to continue to use and enjoy them, while at the same time making them difficult or nearly impossible for an unintended predator to reach. The result is that you radically deter the majority of those predators, and if you do get attacked, you have the tools and systems in place to successfully protect your assets. When this is done well, my clients tell me that they are happier, less stressed, more productive, and have less fear about conducting their business, hiring employees, firing employees, sending their kids off to drive their cars, and in general, feel more peace about their financial security. I know that this is my goal for myself and my family, and definitely for my clients and theirs. So let's take a look at the main tools themselves. First of all, we want to understand how your planning actually works. The goal is to change you in the eyes of the plaintiffs and the predator attorney from an asset-rich target to a legal cost center. In other words, they need to see you as a sinkhole for their time and their effort and their money. So in order for this to work, 4 things must be true. Number 1, your plan must be seen as impenetrable. Number 2, it's got to be skillfully managed, both before you use it and if you ever do use it. 3, your plan can't attract a billable challenge. In other words, the attorney on the other side can't be attractive to challenge the plan, thinking this is going to create revenue for him. And 4, if pressed, your planning really must work. So as a client, I know there are 4 things that you want. And believe me, all my clients want the same things. I want the same thing for my own asset protection plan. These are 1, effectiveness. It has absolutely got to be effective. 2, control. You want to control your plan. I agree, so do I. 3, the cost has to be reasonable and sustainable in the long run. And 4, compliance. You can't have a plan, or you don't want a plan that creates a lot of extra compliance requirements for you and your CPA. So now let's look at the tools. The 3 primary tools that we use are the limited liability company, the asset management limited partnership, and the asset protection trust. So let's start with the limited liability company. The limited liability company is a great first layer of asset protection. It's fantastic to hold things like rental property, office buildings, second businesses, car collections, airplanes, yachts, all of the things that we as an asset protection attorney consider risky. In other words, if it has a door, a lock, a key, an engine, it's all risky. And if it's risky, we want it to be wrapped up in a separate company that limits its liability. That's what a limited liability company does. And so it creates a great first layer of asset protection for those types of assets. The second tool is called an asset management limited partnership. And it's very similar to a limited liability company in that it has a layer of protection around it which doesn't allow a creditor to just get in, break it open, and take the assets. But an asset management limited partnership also works really well as a holding company because it has 2 different classes of ownership. It has a general partnership interest and a limited partnership interest. The general partnership is the controlling interest, and that is typically you serving in that role, which gives you control of your assets. And the limited partnership is typically your asset protection trust. So by dividing that up, we create a distinction of ownership versus control. The asset management limited partnership is great to hold the interest in your other limited liability companies, which hold the assets we just talked about. It can also hold assets that we consider safe, like cash, stocks, bonds, receivables, anything that doesn't have a key, an engine, a lock, a door, all of those things. So liquid assets, investable assets, securitized assets, they can all go directly into the asset management limited partnership. And so the net result is that all of your assets virtually are in either the asset management limited partnership directly or in the LLC that's owned by the asset management limited partnership. So now we have most of the things in one of those 2 tools. The third tool is called the Asset Protection Trust. And this is where it really gets interesting because the Asset Protection Trust, or the APT, is really the heart and soul of the modern asset protection plan. And many of you listening have your trust named an International Wealth Management Trust. Some of you have a trust called the Bridge Trust. And going forward, you're going to hear me refer to the trust as a bridge trust. Rest assured, if you have an International Wealth Management Trust, it's the same trust. But we renamed it a couple of years ago because the concept of a bridge trust is much more clear on how this trust actually works. And I'll explain that a little more as we go on. So, what is an asset protection trust? All asset protection trusts are called self-settled spendthrift trusts. What that means is that they are self-settled. They're settled by you for yourself as your own beneficiary, and they have the all-important spendthrift provisions in them. Spendthrift provisions are the very provisions that allow you to protect the assets of the trust from your creditors. So they are really critical. Now, in the world of self-settled spendthrift trusts, there's two versions. There's the international trust and there's the domestic trust. The international trust came first. It was created in 1984 in the Cook Islands. And it is the hallmark of this trust is that it has statutory non-recognition of any other jurisdiction's court orders or judicial proceedings, which means that if you want to come down and take your U.S. judgment, come to the Cook Islands, present it, and you expect it to have any value, you'll be in for a big surprise because it has no value in the Cook Islands. You would have to start your case all over again. And you'd be faced with proving your case at the highest possible legal standard, which is beyond a reasonable doubt. By the way, you're not going to be able to get a contingent fee attorney like you've probably had up here because they don't allow them in the Cook Islands. And your claim is not amendable. They can't sue you for one thing, get into discovery, and try to change their claim later. It is absolutely unamendable. And if you lose, which with the burden of proof beyond a reasonable doubt you almost certainly will, then you have to pay the legal fees of the winner, which of course is my client. And finally, the statute of limitations has probably already run before someone attempting to get into one of these trusts even takes a shot. So the net effect is that the Foreign Asset Protection Trust has been around for over 30 years, and we have a very strong case history of how well these work. And they are incredibly strong. So if we go to the four things that you want as a client, number one is effectiveness. On that front, the Foreign Asset Protection Trust gets 5 stars. Now, what about the other three? Control, costs, and compliance. Well, not so good there. First of all, if a Foreign Asset Protection Trust is really going to work, you've got to be out of control. In other words, the foreign trustee needs to be in control for that to work. 2, the costs are going to be higher. Some of you on the call have probably needed to trigger your trust, and you know that the costs move from about $1,500 a year to well over $5,000 a year to maintain a foreign asset protection trust. And compliance. If your trust is a foreign asset protection trust, you have IRS reporting requirements. You have a 3520, 3520A, the FinCEN, the FBAR, and the FACTA disclosures. So none of these things add an extra tax, but they absolutely do add costs and expense as well as maintenance to file every year. So let's take a look at the domestic option, because I know as clients you call me and you're hearing about these trusts and you want to know, is my trust a foreign trust? Is my trust a domestic trust? So the domestic trusts are newer. They were started in 1998, and the first state to have one was Alaska, to pass a specific statute that allowed for a domestic self-settled spendthrift trust. Well, now we have 16 U.S. states that all have passed some form of domestic asset protection trust legislation. So in my book, that's good news. It says that we believe in the concept. The naysayers of 30 years ago that said asset protection is never going to be a legitimate field of law are absolutely wrong. We have a third of the U.S. states that respect the concept and have drafted specific legislation to allow for the very same type of trust that was created 30 years ago in the Cook Islands. So let's go to our 4 things that I know as a client you want. First of all, what are the good sides of the domestic trusts? Well, cost and compliance. The cost is typically lower and the compliance is non-existent because it's not a foreign trust. And the compliance really comes in with the foreign component. So that's the good side. And I can tell you, because of those 2 things, domestic asset protection trusts are becoming very popular, particularly because attorneys who haven't practiced in this area are more comfortable using the domestic options. So what about the other 2? Effectiveness and control. Well, on this front, the domestic asset protection trust, in my opinion, completely fails. First of all, these trusts have been around just about half as long as the foreign counterpart, and we already have several very high-profile failures of domestic asset protection trusts. And when I say failure, I mean the assets were breached and they were lost. That to me is unacceptable when it comes to developing and implementing your own asset protection plan. Why do they fail? Well, like I said, the hallmark of a foreign asset protection trust is non-recognition of any other jurisdiction's court orders or judicial proceedings. Well, the hallmark of all of our domestic laws is the U.S. Constitution. And the U.S. Constitution, in Article 4, Section 1, provides that every state must grant full faith and credit to the judicial proceedings of every other state. So that means Nevada can pass an asset protection statute, but it cannot ignore a California court or a Georgia court or a New York court. And so on that front, the domestic trusts are very, very different. Also, control. Even if you think that a domestic trust is a good option for you, there you need to be very strict about the control component, and you need to make sure that as a client you are not in control of your trust if you have any hope that that trust is going to work. So as a client of Lodmell & Lodmell, which one of these two trusts do you have? Well, and the answer is that you have both. And that's why we've called it the Bridge Trust. Your trust is a foreign asset protection trust, registered in an offshore asset protection jurisdiction. You have an offshore special successor trustee that is ready to go, standing by, and has already done the due diligence on you and your trust. However, for the purposes of the IRS code, your trust is considered domestic for tax purposes. And that means that there is no IRS filing requirement, there's no FinCEN or FACTA disclosures. In fact, there's no IRS filing requirements of any kind. Assets can remain here in the United States with your current financial advisor and your current bank. You do not have a foreign trustee who's in an active role from day one. In fact, as you know, you can be your own trustee. Your trust is a tax-neutral domestic grantor trust, which is why it does not require its own separate tax ID number or its own separate tax return. However, your bridge trust, if threatened with an event of duress, which we would typically call a lawsuit or any other thing that would threaten the assets of the trust, can cross the bridge. And at that point, it becomes a fully foreign asset protection trust. At that point, your special successor trustee in the Cook Islands would take over, you would move the assets, and you would have the full protection of the foreign jurisdiction and what I consider the best jurisdiction in the world, which is the Cook Islands. It's for this reason that we have been so successful in using the Bridge Trust to protect our clients' assets. So let's put it all together. First, let's lay out the tools. We've got the Asset Management Limited Partnership. That's your holding company. That's your primary vehicle in the center where you're going to consolidate the bulk of your assets. Next, we have your limited liability company. These are going to hold your real estate, your boats, your planes, all of your risky assets. And you have your bridge trust. And let's also put up there your revocable living trust, because this is still an important part of your overall plan. So the limited liability company is going to be owned by the Asset Management Limited Partnership. So all of those risky assets are going to in turn be held by your holding company. What goes in your holding company directly? Your cash, your investments, your liquid assets, your stocks, your bonds, your receivables, anything that can't hurt someone else. In other words, that is not risky. Doesn't have a key, a motor, an engine, a door, something that you don't typically have to buy liability insurance for. You're going to be the general partner of the limited partnership. This gives you the control of the assets in your holding company. And your bridge trust is going to be the majority limited partner. That's the non-controlling interest, but it's the ownership interest. So at this point, one of two things is going to occur. Either you die and you need to pass your plan on to your heirs, in which case you're going to follow down to your revocable living trust, and the assets are going to distribute per your instructions inside your trust. You're going to maximize your estate tax exemptions, and you're going to avoid probate and smoothly pass your assets. Or you're going to have some type of crisis, in which case we're going to go to the bridge trust, and the assets are going to flow through, And if necessary, we're going to cross the bridge with those assets and remove them from the threat altogether, including outside of the United States, if that's what's necessary. So now you see how it fits together. I hope this makes sense, and if I've raised questions, please ask them here. So what developments in the asset protection world do you need to know about? Here are the top 3 updates for 2016. First, asset protection has become one of the most important fields of law today. The failure of tort reform and the lawsuit crisis, which I talked about in my book, The Lawsuit Lottery, has only gotten more critical. Asset protection is here to stay. Second, we had a major change in the estate tax exemption in 2015. Congress finally resolved the issue and increased the individual exemption to $5.43 million per person. This is further adjusted for inflation each year going forward. What this means now is that a married couple can exclude over $11 million in assets. For most of my clients, this is very good news. However, for estate planning attorneys, this has had the effect of dramatically reducing the need for some of the more complex estate strategies, and this has changed their business. If you combine this with the fact that asset protection has really come of age, we now have a lot of attorneys who are transitioning their practices into asset protection. My feeling is that overall, this is a good thing. I really believe in asset protection and that it is a critical planning tool. And it's time that more attorneys incorporate it into their practice, especially those doing estate planning. This is part of why I also started the Asset Protection Council, to support those attorneys who don't yet have the experience or desire to do it alone and want to leverage our experience to support their clients. And number 3, I want to bring up an important piece of legislation that actually happened along the way in the asset protection world. This was actually way back in 2005, but because it directly affects the most important asset protection tool we use, the Asset Protection Trust, and I know that most of you are not familiar with it, I want to talk about it. This is the legislation that is called the Bankruptcy Abuse Prevention and Consumer Protection Act of 2005, also known as the new bankruptcy law. This legislation was written by banks and lenders, and the net effect is that it made it more difficult to benefit from bankruptcy. For our purposes, I want to look at Section 548, specifically 548E, which has the effect of making transfers to a self-settled trust made within 10 years of declaring bankruptcy includable in the bankruptcy estate. So why is this important to you? Well, your bridge trust is a self-settled trust, and you are the beneficiary of that trust. And why this is really important is that if your trust is already 10 years old or even approaching 10 years of age, then you have just about the strongest possible trust on the planet, considering that under Section 548E, this trust should be excluded from even your bankruptcy estate. I get clients who call from time to time and say, well, I'm retiring and thinking that I don't need to keep my planning in place. My response is twofold. 1, while your risk may have gone down in retirement, your earning capacity has also gone down, or perhaps completely gone away. And 2, if your trust is over 10 years old and you still have assets which you need, I am extremely hesitant to recommend that you do away with it. The real message here is that the longer your plan has been in place, the stronger it becomes. The bottom line is that asset protection is important, and you, who already have it in place, are way ahead of the game. There's also been quite a few interesting cases, mostly cases in which the domestic asset protection trusts have failed to protect assets. I don't want to take the time to go over each of those cases here, but I have full case briefs of all those cases on the Asset Protection Council website, and you are welcome to see them there. So we're almost done with this year's update, and I want to remind you, if you have any questions or if you haven't done your own personal annual review, contact our office and get it scheduled. I sincerely appreciate your trust and confidence in choosing us to assist you in protecting your family. Before we move to the questions, I also want to encourage you to think about what having this planning has done for your own personal state of mind around your business and your family. If it's been a benefit, then I encourage you to share this information with your friends, your business associates. We would be happy to work with them, and if they do become a client, we'll be happy to waive your annual fee for that year. Thank you again for joining me in our Lodmell & Lodmell 2016 Client Update webinar presented by the Asset Protection Council. Let's get to the questions because I know there are a lot of them. Thank you so much. Okay, so the first question is, what about intellectual property like a patent or a copyright? This is a great question. It's really important. So intellectual property can go in one of two places. It can go either directly in the limited partnership. So if you have a copyright, let's say you've written a book and it sells and you get royalties from it, that's like a securitized interest. It's not really creating any liability. So it's what I would consider a safe asset. So it is able to go directly into the limited partnership. The other option is that if it's a very valuable patent portfolio or copyright or any intellectual portfolio which has a lot of value to it, then we probably want to actually put it in a separate LLC. And that separate LLC would own it, and that in turn would be owned by the limited partnership. This is particularly true if there's a lot of royalties coming in, and we need to manage that separately. Sometimes some of my clients have actual patents or intellectual property that is international, and they're receiving royalties internationally. In those cases, we might actually use an offshore asset protection system or an offshore LLC in order to hold the intellectual property. But we want it in the plan. I mean, it's valuable, so we definitely want it in the plan. So great question. Thank you for that one. The next question was, what about S Corps, C Corps, and limited companies? How should these be owned? Thanks for asking this question. So C Corps, as you know, can be owned by any type of entity. So if you own Apple stock, you can put it in your trust, you can put it in your partnership, you can put it anywhere you want. S Corps are different. S Corps have restrictions on ownership. And because they have restrictions on ownership, they can only be owned by two types of entity. One is a person, meaning it's a living, breathing person, somebody who's actually breathing. And two is a special type of trust called a Qualified Subchapter S Trust, QSST. And fortunately for us, your bridge trust is capable of being a QSST. So if you have valuable S Corp shares, we can put it in the QSST. And that's whether we should or we shouldn't depends on the S Corp and what it's doing. One of the other principles of asset protection that I always use and that is very important is separating the risky assets from the safe assets. So we talked a little bit about the safe assets there and how we want to put them in one place and the risky assets in another place. So with an S Corp, oftentimes it kind of represents both because it's out there doing business in the world, which means it can also be considered a risky asset, but sometimes it also has an incredible amount of value. So we have to balance that. So this is just something we do on a case-by-case basis. So if that's you, of course, call the office and we'll discuss it. Okay, next question. Actually, this is a follow-up question from the same questioner. What are the best states for LLCs? LLCs are, and in the question he went on to say, I know some states, single-member LLCs don't have protection anymore. We had a pretty famous case here in Florida called the Olmstead case where the court actually said, well, it's a single-member LLC, and they actually disregarded it and they broke into it. They actually addressed that in Congress here because no state wants to be known for being weak and having wimpy protection laws. States are in the business of attracting business to their state. You see, that's why states give tax concessions to large companies to move their headquarters there, to open up a plant there. The same is true with small business. States are trying to attract those fees, even if they're small fees. Annual registration fees of a few $100s make a difference when there's literally tens of thousands of them. So states do compete for being better. I can tell you that LLCs are the best states for LLCs are those where it is absolutely a statutory exclusive remedy being the charging order, and where we have a good history in the state. So some of the big ones that come to mind are Wyoming, Nevada is popular, Delaware is good, Arizona, of course, is excellent, and we use that a lot. Some of the bad ones or the ones that aren't as good are just the states that already have problems, like California. But here's the thing with an LLC. The most important thing to remember is that the LLC alone is never as good as an LLC that is inside of a limited partnership. And the reason is that the limited partnership adds a whole nother dimension to the plan. Because even if it's a single member LLC, the partnership is not single member. And you've also diversified jurisdiction. So regardless of what state you're in, let's say you're in California and you have some rental property, then you would most likely just use a California LLC, even though they're not known particularly for their strength. The fact that the property is in California kind of means we gotta stick with that, because California is going to look at any LLC, whether it's originally formed in Wyoming or in California, and say, well, you're doing business in our state by holding a piece of property, therefore you're going to be subject to our laws. So it's really that layering up to that next level of the limited partnership that is the important part of the LLCs. So again, it's using the right amount of tools and the right amount of layering, not going too far, keeping it simple enough to manage. And in that sense, a single member LLC is good because it doesn't require an additional tax return. And a single member LLC held by a multi-member partnership is good. And that means you could have 10 single member LLCs and all into one multi-member limited partnership, and you're only going to generate one extra tax return. And that's what, again, my clients want. We want simplicity, we want control, we want it to work, but we don't want to create plans that are so complicated that you can't manage them, and after a few years your CPA talks you out of continuing it. That's kind of the worst case scenario, is that you cancel your plan before because you can't maintain it and then you need it. So great questions. Okay, next question is, can I move my cash, which has been sitting outside of my planning, into my planning if I have a problem? And the example he gave was, let's say I have $100,000 that's sitting in my working capital and I need that, and now I have a problem. Can I put it into my plan? Well, the answer is not a bright line. It's not automatic whether we can put it in or not. It depends on the circumstances. Bottom line is that the most important thing is to have your plan done and funded properly with the bulk of your assets. You are going to have some assets that are outside of your plan. You're going to need it for working capital or for just your general, it's not in the plan. The reality is that lawsuits and threats to your wealth take a long time. That's kind of a good thing in your case. When you already have asset protection in place, that length of the legal system plays in your favor. When you don't have asset protection planning in place, it plays against you. So you really turn the tables completely by having your asset protection plan already set up. Because what previously worked against you, these long time delays of getting into court and months between filings, that used to be working against you. Now it works for you, because it just gives you more time to figure out how your next move is played out best. And when you have asset protection established beforehand, then you have the capacity to have moves and make moves that you never would have been able to do without your asset protection. So great question. So next question is, the Asset Protection Council. So the Asset Protection Council, I am really proud to announce it. And the question is, what exactly is it? And it looks like it's something that I could refer my financial advisor or my CPA or even my local attorney to. And the answer is yes, that's exactly what it is. So we have really become a leader in the asset protection community. And we, a couple of years ago, actually several years ago, were getting pretty regularly calls from other attorneys and financial advisors and CPAs, but particularly other attorneys saying, hey, I've got a client, I don't do this, can I refer them to you? And it got to the point where we realized that this was a big need in the community, in the legal community. So the Asset Protection Council is actually our official affiliate program. And we've really put a lot of effort into it. And when I say a lot of effort, I mean really a lot of effort. And we are supporting other attorneys with their clients' asset protection needs. We're also supporting the CPAs of our clients, the CPAs of their clients, and the financial advisors, because everyone now has really figured out that asset protection is critical. It's no longer, I mean, 15 years ago, people didn't quite know what it was. 30 years ago, it wasn't even a concept. It wasn't even a twinkle in your father's eyes, as they say. Today, it is really the hottest legal topic out there, certainly in the estate planning world. I can't go to an estate planning conference without the whole thing kind of turning into an asset protection conference, because this is what people are asking about. This is what clients are asking about. So it is really, I'm very happy and proud to have launched the Asset Protection Council. It's definitely something that you can go to as a client of mine, and you can certainly refer your CPA, your financial advisor, or even attorneys that you know. We're here to support all of those people. Okay, so here's a question. So if you're sued and you move your assets offshore and your plan is less than 10 years old, does one do bankruptcy to get rid of the current liability? Okay, so this gets into the big issue that I talked about, which is the 2005 new bankruptcy law. And I know that's old. I mean, that's 10 years old, but it is so critical when it comes to asset protection and so misunderstood. Not a lot of people understand exactly how that affected the self-settled spendthrift trust. And this 10-year look back was designed particularly with the domestic asset protection trust having come online in 1998 and gotten really popular by 2005. Congress was worried, actually I shouldn't say Congress, I should say the banks and the bankers and all the people who lend money were worried that they were going to miss out on, people were going to just run to the domestic asset protection trust, do a trust, declare bankruptcy, and protect all their assets from their creditors. So the 10-year look back is designed to not let that happen. And I think that's a good thing, and we don't want that to happen. I mean, that's not the goal of asset protection. Nobody should be trying to get out of creditor, declaring bankruptcy and pulling a fast one. I mean, that's not what we're doing. That's not good for the industry. It's not good for legitimate people that are doing asset protection because they want to really protect their assets. So the 10-year look back was designed to solve that. Well, the flip side of that is that after 10 years, what they're saying is okay, well, if you've had your trust for 10 years, clearly you weren't running to do bankruptcy. It's excluded from the bankruptcy estate. So it's just a superpower hidden Easter egg that the statute built in there. I'm not sure they thought about it too hard. But as far as the question goes, no, if you have a trust that's less than 10 years old and you get sued and we have to trigger the trust and cross the bridge, bankruptcy doesn't have anything to do with it, because we're using the trust to protect assets. And for the record, I am not a fan of bankruptcy. That is not the way I recommend my clients go. Asset protection is so strong and so powerful and so capable of handling the issues and stopping the collection and resolving the issues. I very, very rarely see a client that determines that bankruptcy is the best course of action. I mean, it almost never happens. So bankruptcy is not a big thing. This is just a bonus. And it's a reason why also, when you're looking at your trust, and I know many, many of you on this call, on this webinar, your trusts are 10 years old, or they're approaching 10 years old. They're 6, 7 years old. I just wanted to point out that your trust gets stronger with age. It just keeps, it's like concrete. It just never quits hardening. And the argument against your trust is fraudulent transfer, which says that you transferred assets with an intent to delay, hinder, or defraud a creditor. Well, when your trust is 10 years old, 15 years old, that argument is ridiculous to say that somebody you didn't know 10 years ago, you were trying to protect against them. So I am, again, all of you on the call are way ahead of the curve. I mean, asset protection, I believe in the next 5 and 10 years, you are going to see this become a major industry. And you guys are so far ahead in putting your plans in place. Your plans are going to be stronger and are stronger than anything anyone can put in place, tonight for tomorrow's problem. And if you haven't put your plan in place, if somebody is listening to this and they haven't, the message is put it in place as soon as possible. Don't wait till you have problems. That's the toughest thing you can do, is wait till you have a problem and then try to figure out on, how do I protect my assets? And unfortunately, a lot of people do that. So, okay. Let me answer the biggest one there, how my asset protection planning works with my estate planning. Since that's the number one issue, let's just take a minute and talk about that. So you all have an asset protection plan that's comprised of the tools that we talked about today. The Asset Management Limited Partnership and the Bridge Trust, and many of you, if not most of you, have some LLCs to go with it. You also have some type of estate plan. And the estate plan is comprised of either a revocable living trust or a will, one of the two. And what the estate plan is versus what the asset protection plan is the estate plan is, at my death, what's going to happen? Who's going to get my assets? And so the estate plan answers questions like, how do I divide them up? Who's going to get what? What should be done with certain assets that I don't think my kids really are up to managing when I was alive, or my business? And it's really important that you have an estate plan. And it's also really important that it be updated fairly regularly. So one of the other things, and so how it works, let's continue on that. How it works is that your asset protection plan is funded with your assets. So they're in your limited partnership, or they're directly in your trust in the case of your primary residence. It's usually, depending on your state, but in most states it's directly in your bridge trust. At your death, what happens is that those tools, particularly the bridge trust, have a provision in there which tell it to look down to the revocable living trust and to distribute assets to the revocable living trust, or if need be, per the revocable living trust, to the beneficiaries. So it's a mechanism that looks at your estate plan to distribute per the estate plan. What this allows you to do is a couple of things. One, not monkey around incessantly with your asset protection plan. We want it to be old and cold. We want it to be in place for a long time, and we want it to be fairly static. In other words, we're not making changes and doing things inside of your asset protection plan. Your estate plan is different. That's not static. You can change your mind. You're going to have more kids. Things are going to happen. Kids are going to get married. You're going to want to make, your assets are going to change. That's much more of a living document that needs to be revised and reviewed regularly. Also, changes in tax law, which we just talked about it, right? So what used to be, back when I started, the estate tax exemption was $640,000. I mean, it was very low. Then they changed it, and it climbed up, and it was $1 million, and then it was $3 million, and then it was unlimited. And I don't know if you all remember, but George Steinbrenner, the owner of the Yankees, died the year that the estate tax was unlimited. So that guy was just lucky, right? His whole life. His estate passed with 0 estate taxes, his multi-million-dollar estate. Well, the next year it flipped back to $1 million. So it's been a bouncing ball for the past 10 years, frankly. Finally, this year, the 2015, Congress said, okay, let's just stop all this. We're setting it at $5.43 million per person, and we're going to adjust it for inflation. So this year they just came out with a new one. It's $5.45 million now per person, which means for a couple, that's nearly $11 million this year, and it will be over $11 million and growing every year. That handles the vast majority of most people's estate. But your trust should be regularly reviewed. So one of the things that we also are very happy about with the Asset Protection Council is that we are now able to have attorneys in every state that are members of the council that are familiar with your asset protection plan and how that works, who can adjust and review and revise your estate plan. So if you haven't had it updated in the last, I would say, 5 years, it's time to do it. You can contact us. We can refer you to an attorney in your area that's part of the council. You may already have an attorney. You may have done it with a local attorney. You can go back to them. If you do have an attorney that you're working with locally for the estate plan, I really encourage you to refer them to the Asset Protection Council, and it will help them understand your planning, and it will also give them access to the entire suite of asset protection for their other clients. And it's really become a very popular thing. So I hope that answered some of the question around that. And so let's take a minute and answer another question. Okay, so can you comment on the charging order? Yes, the charging order is that is what gives an LLC its protection. It's also what gives a limited partnership its protection. So the best way I can explain a charging order is to talk about it in terms of stock versus membership. So if you have stock in Apple, that is nothing but an asset. And depending on how Apple is doing that day, it can be a more valuable asset or a less valuable asset. But it's an asset. So if you get a judgment against you, the court can say, hey, give me your assets. And one of those assets is my stock in Apple. And that includes my stock in my private company. So if you own your own private company, that's where you do business, and you have it as a C corporation, those shares are seizable by a court. The same is true if it's an S corporation. Those are also seizable by a court and can be given to your creditor. An LLC is different, and a partnership is different. And they're a little bit different for different reasons. But an LLC doesn't have any stock certificates or stock ownership. It has members, and the members are the owners. But just like membership in a private club, it can be exclusive, and it can have rules around it. And one of the rules that the LLC membership has is that a member cannot be someone who received their membership interest to satisfy a judgment. In other words, we exclude creditors as members. You're not allowed. So we can discriminate inside of our limited liability company and say creditors are not approved to be members. And that's how it protects. But that doesn't mean that the creditor is helpless against the partnership or the LLC. What they then get instead of actual membership interest, they get what's called a charging order, or a charge against any future distributions that the member might get. So they don't get to get the membership interest, and they also don't get to get the underlying assets, but they do get a right that when the member finally gets a distribution someday, they're in line and they're actually entitled to get the distribution. So it gives you quite a bit of leverage. It's not a full solution because you haven't made it so that the creditor can never get it. They still have this right, but it's not the same thing as them being able to grab the assets and just satisfy the judgment. And the partnership's charging order, in my opinion, is even a little stronger, because a partnership is an even more closed and a sacred form of agreement than a member. So think about it this way: a country club might have 200 or 500 members. Well, a partnership is usually 2 or 3 people. I mean, you know, when you go into partnership with someone, it's usually very small. And the charging order protection in particular around an Arizona limited partnership is excellent. And that's why we use the Arizona limited partnership. And we draft it very specifically to maximize the statutory specialties of Arizona and all of the provisions to make it very strong. And that's why we call it an Arizona Asset Management Limited Partnership. And that's what you have. If you have a limited partnership drafted by us, that's what you have. And so the charging order is very, very good. I really, really like it. When you combine that with the capacity through the bridge trust in a true emergency to go offshore, well, now you've really done something special, because you still have the charging order protection, which is valuable and means we don't have to just run and trigger the trust and cross the bridge at every little problem that comes up, because we have this very strong charging order protection. But if we have a major, major problem, we have the option to go offshore. So statistically, I'll share with you that in my client base, over the past 18 years, we have had 2.5% of our clients need to actually trigger the trust and cross the bridge. And that's in my opinion, that's just right. It doesn't mean only 2.5% have used the planning. Many, many more, probably in the order of 15% or more plus, have called me saying, "Oh my God, Doug, I have to trigger my trust." But the vast majority of those, we don't actually have to. We're able to play the poker hand in such a way where we don't need to. But 2.5% of the time we do. And fortunately, we have been successful in all those cases where we've had to trigger. We've never had a creditor follow us to the Cook Islands or attempt to break into the trust, and certainly never had anyone break into the trust, which I'm very proud of, and I'm knocking on wood. So great question. Thank you for asking that one. So the next question is, so can we pass assets to kids, and is the trust amendable? Okay, so I'm assuming that the question is referring to the bridge trust here, and the answer is you can absolutely pass your assets to your kids. The way you do that is through your revocable living trust, and then the bridge trust will look down through that. And I'll tell you another feature of the bridge trust that would makes this really valuable, is that if you're passing assets to your kids through your revocable living trust, and you die in some way, or you leave when you die a significant liability or a threat to your assets, the asset protection trust, the bridge trust, is going to stay in place to protect your children and the assets from that liability that you left. So the example I sometimes give is, you die in a car accident, and the other car had was a bus full of brain surgeons on the way to a conference, and there was about $100 million of earning power in there, and the liability is just out the roof. And in a normal case, your estate would be liable for that, and you'd have to your state would pay, and your kids would get nothing. If you have your asset protection plan in place, your bridge trust is going to look at that situation at the time and say, okay, well, we're not going to give it to the estate, which is going to lose all the assets, but we're going to adopt all the provisions of the estate plan. In other words, all of the distribution provisions of the revocable living trust, we're just going to adopt them, and then we're going to give it to the assets to the beneficiaries directly. And so that is, a huge benefit, and again, part of your plan. And a really important feature, I believe, is the fact that you can protect assets through the generations. And my clients are starting to hit the point where they're really thinking about that. So the plan is incredibly flexible. The question is the trust amendable? Yeah, the trust is amendable. You can adjust it. There are provisions in there which allow for that, and it's extremely flexible. So, we can pretty much do anything we want as long as a court is not there telling us to do it. But that's why it's so important to lay this out directly in your trust. The trust has to be right. You have to set this up in just the right way. Okay, so here's a question, Doug. We've had our asset protection trust since 2002. Congratulations, right? So you're way over 10 years old. Fantastic. We recently went to a local attorney to update our wills. She was very critical of the trust, and trust as set up, and advised us to let it expire. We are having a difficult time with the changes. She said the present trust, and it's not valid in her state, New Jersey. Okay, so thank you for asking this question. And this is a really important question because it happens a lot. First of all, the trust is not a New Jersey trust, so it doesn't really have anything to do with New Jersey. The attorney that's reviewing that is, I am sure, very qualified, and this is an estate planning attorney, but asset protection is different. Your trust is a very special kind of trust. New Jersey is not one of the domestic asset protection trust states which allows for this type of trust. So I can understand why she said that she doesn't understand it. But you have to be responsible. You know, one of the things we say here is it's your money, act like it. I absolutely do not advise you to let your trust expire. You, in particular, have a version of the trust that is incredibly strong because of its age. It's now 13 years old. I mean, it is incredibly powerful. So you have a couple of options. One is get me on the phone with that attorney, and I will do my very best to help her understand how this trust is drafted, understand how it fits together with the estate plan that she's doing or with the wills, and get her on board so that we're all on the same team. That's my first choice. That's what I would love to do. The second choice is if she either won't get on that call, which does happen sometimes. People just don't they don't want to talk about it, or just unwilling. Then we have to discuss another option for you. But I can tell you that your trust is not only valid, but as strong as it could possibly be. And the last thing you want to do is get rid of it on advice that is not complete. And this happens, and I'm glad you asked the question, and I'm glad I'm able to address the question, because this happens both with attorneys, it happens with CPAs. I would also refer her to the Asset Protection Council website. There's lots of information there. Remember, asset protection is new. It's hit its stride, in my opinion. It has absolutely hit its stride. We are very much in the conversation of asset protection everywhere I turn, but it is still in the legal world. 30 years is still a new thing. And so a lot of attorneys are just now hearing about asset protection. They just heard something at the last conference they went to. And so, it is not, in that sense, mainstream. So just please, get the right answer and frankly, get her on the phone with me so that we can address it directly. And thank you so much for asking that question. And I just want to also tell you all, you are the most important people in my life. I mean, my family and my personal life, and then my business. And my business is my clients. And I mean, you guys are the reason I get up in the morning. You're the reason I put all the effort into what I do. You're the reason I keep thinking of new ideas and ways to communicate. And I just want to thank you because, you guys are great. I talk to other attorneys who are very unhappy. Most attorneys make the joke that they're, in some type of attempt to retire from law. I don't feel that way at all. I am extremely pleased to be an attorney. I'm extremely pleased to be an asset protection attorney. My clients are my friends. They are on my team. I am on their team. It's just an area of law where, by the nature of what we're doing for each other, we are on the same team. And while I've got you here and I've got your attention, I just want you to know that you guys are really the most important people in my life, second to my family. And I really appreciate you. Anything that you need from us, I know you all know this because my staff is absolutely fantastic. And of course, I couldn't do this without my staff. They're all on the call today. And, all of the team members that we have, we work very, very hard to be, almost instantaneous in our responses to you. And I know you're all used to that, and sometimes we laugh. We go, "What have we created here?" We're attorneys that get back immediately and have things done the next day. Nobody does that, but that's just the way we like to be. That's our corporate DNA, and I don't see us changing. So thank you for being clients, for coming on here, for taking the time to get educated more. If I did not answer your question, it either means I didn't see it in this giant list and I couldn't figure out what it was, or it was too long for this for this format. I will answer every question. So I will go back through here and I'll look at all the questions I didn't get to, and I'll send you an email answer for the ones I didn't get. And thank you for asking them. So that's it. We've run over our time limit, and I want to thank you for joining us for our 2016 Client Update webinar. Everybody have a fantastic weekend and a great year. I look forward to it, and we will see you next time. And thank you.